My name is Madison Cartlidge, and I'll be talking about prenuptial agreements and whether they should be accepted within the English legal system. Family is a living and very emotional part of law. Redistribution of assets at divorce is no exception to this. Each case is very different to the next and can be treated as such through the Matrimonial Causes Act 1973. This is because the legislation governing this area of law is broad, vague, and left to the interpretation of courts. Section 25 of the Matrimonial Causes Act gives a long list of matters for the judge to take into consideration when deciding a case. These include earning capacity, financial needs, and the standard of living, to state just a few. These aspects are given different weight by the judge, which is then translated into a financial order or ancillary relief. A list of financial orders can be found in Section 23 of the Matrimonial Causes Act. There are many different kinds of financial orders, such as a property adjustment order or lump sum. When looking at financial orders, the case of White and White is a significant one because it was this precedent that set a new standard for the redistribution of assets at divorce using the yardstick of equality. Miller and McFarlane developed the landscape of redistribution of assets at divorce. It was this precedent that asserted equality through equal sharing with the principles of need, compensation, and sharing. This movement towards equal sharing is the main incentive for the wealthy to enter into prenuptial agreements, as the contract ring-fences assets that would otherwise be shared at divorce. Prenuptial agreements can be a very risky tool when not governed properly, which can be attributed to the lack of use within the UK jurisdiction. The Supporting Families Green Paper took the first steps in governing this area, but was quickly rescinded due to the lack of research. Nevertheless, it transformed the area by giving 6 safeguards to govern what should be included in a prenuptial agreement in order for it to be valid. These are giving provisions to children of the marriage, whether the agreement is unenforceable, if both parties obtained legal advice, whether by allowing the agreement significant injustice takes place, if either party fails to disclose their full estate, and finally, whether the agreement was entered into less than 21 days before the marriage. Though the Green Paper was rescinded, these safeguards were discussed at great length in the judgment of Radmacher and Granite Eno, which I'll be coming to shortly. Not long after, a paper by Resolution, an organisation made up of academics and practising family lawyers, gave support to the use of prenuptial agreements, but insisted that it had to have legislation to avoid the weaker party suffering financially through the use of prenups. The case of Radmacher and Granite Eno regards a husband of French nationality and a wife of German. Both had substantial assets. The wife was due to inherit a great amount, so called for a prenuptial agreement to protect the family's money. During the marriage, the husband took on a research role with a lower salary in order to move into a niche area of banking. In the family division, the prenuptial agreement was given very little weight by the judge, as she identified it to follow none of the safeguards from the Supporting Families Green Paper. This was evidenced by the husband's lack of legal advice or negotiations taking place. The judge followed the judgment of Lord Nichols in White and White concerning the doctrine of fairness, and so awarded the husband a grand lump sum of £5.6 million, consisting of 2.5 for property, 700,000 for debt, 25,000 for a car, and 2.35 million for maintenance. Much of the lump sum was given to aid the husband's role as a homemaker for the 2 children of the marriage. It could be argued that the judge, in following Lord Nichols, and trying to create a fair outcome erred purely because fairness is a warped concept where prenuptial agreements are involved. The parties' intentions are apparent at the time of signing the contract, but may have changed at the time of divorce. The Court of Appeal determined the judge in the family division had erred in her judgment. The safeguards were correctly identified as being disregarded in the making of the prenuptial agreement. However, when taking into account other factors, such as the husband's competent role as a successful banker, meaning he would understand the concept of the contract that he was signing, this attributed more weight to the prenuptial agreement and therefore reducing the lump sum given to the husband to 2.5 million. This can be seen to be an important turning point in the case. The importance of this turning point is the clear move from fairness towards prenuptial agreements, what used to be considered harsh and unjust rule. The case then progressed to the Supreme Court, where we see a support for what was decided in the Court of Appeal, echoing the error of the family division judge. The judge considered the case of McLeod and McLeod, which limited the weight of nuptial agreements to only post-nuptial agreements, these being made after the marriage rather than prenuptial agreements being made before. They dissented from this judgment, stating that both versions of the agreement should be given weight. They considered the supporting family's green paper and developed 3 safeguards for the future courts. These safeguards say it must not be unjust to hold both parties to the agreement, circumstances prevailing. The agreement must be freely entered into, and there must be full understanding of the implications entering into such agreement. This takes resemblance to some of the safeguards from the supporting family's paper. Finally, the final decision in the Supreme Court justices was to give full weight to the prenuptial agreement and only award the husband a lump sum in order to carry out his homemaker duties, though knowing that the sum given was more than enough to assist him beyond that role. The Law Commission Report 343 concerning prenuptial agreements gave 6 safeguards after the point of Radmacher, though was eagerly anticipated in the case of Radmacher and Granite Eno. The first was contractual validity. This provides that prenuptial agreements must satisfy what a normal contract would, the basic requirements of a valid contract being that there should be an agreement, consideration, and an intent to create legal relations. This is a really good safeguard to include, as it affords the parties the same protection that there would be in normal contract law. This is that if any undue influence or anything similar to that were to occur, that the contract could be set aside. The second safeguard is execution. This requires the prenuptial agreement to be in writing with signatures from each party. The Law Commission, echoing the Law of Property Miscellaneous Provisions Act 1989, Section 2, subsection 1, where it states a contract for the sale or other disposition of an interest in land can only be made in writing and only incorporating all the terms which the parties have expressly agreed in one document or where contracts are exchanged in each. I felt this was a really good safeguard to include, as it puts a lot more prominence on the contract, so it wouldn't be made with fleeting decisions. Timing is the third safeguard. This gave 28 days between the signing of the contract and the actual wedding itself. The Law Commission felt that this was to help towards the expulsion of duress, so people could feel less under pressure to sign an agreement, as it wouldn't be dealing with family and friends coming and then you having to send them home because you've decided not to go ahead with the wedding or the prenuptial agreement. However, it can be seen as unrealistic and not needed, as there is not much difference between the day of the wedding and the day of the contract being signed. There can be seen to be equal amount of pressure in both. Disclosure is the fourth safeguard, and this is to ensure parties understand the ramifications of signing the contract. A nuptial agreement would remove any Section 25 protections that either party would receive under the Matrimonial Causes Act, and would, given the parties' needs were met, oust any input by the court. There is a lot to be said about this because in the case of Radmacher and Granite Eno, the wife didn't give full disclosure and the husband never really understood exactly what he was opting out of. So 5.6 million could have been a very small percentage of what he was going to get. Legal advice is the final safeguard. This demands the couples seek legal advice as to understand the implications of entering into such agreements. Though English law does not often insist upon legal advice being sought, in times where one is contracting out of protection, such as where one allows the use of a house as security for another's debt, the same aspects can be seen with prenuptial agreements. As has already been stated many times, to sign a prenuptial agreement is to contract out of the protection of Section 25 of the Matrimonial Causes Act. The landscape now is filled with confusion, as displayed by the two cases of Kremen and Agrest, contrasted with the cases of V&V. In the first, prenuptial agreements were given no weight, as the judges determined that Radmacher and Granite Eno was an unusual set of facts that could not be followed, compared with the second, which disregarded the safeguards set out in Radmacher and Granite Eno, giving decisive weight to a prenuptial agreement despite the lack of legal advice and distinct power imbalance between the couple. There is the Divorce Financial Provisions Bill being considered in the House of Lords at the moment. This shows a clear move towards forward to govern this area, otherwise confusing and hazardous. The current bill can be seen to follow the safeguards advised by the Law Commission, but as it is still in the drafting phase, I felt it unnecessary to list them at this point. There is a distinct difference between how things were before Radmacher and Granite Eno and how things are now. There is a dual track when dealing with divorce and the redistribution of assets, as you can choose a divorce through family law, in which the courts will redistribute assets based on case principles found in White and White and Miller and McFarlane, equal sharing, and then through private law with prenuptial agreements, which can be upheld depending on whether they are valid under the current safeguards available. And these can govern and even limit the distribution of assets at divorce. Prenuptial agreements do not negate the development of law that has been done. It does not remove fairness, but instead gives an alternative option to them based on a mutual understanding. Most importantly, the judiciary remains a part of both tracks of divorce. Redistribution of assets as a safeguard, has safeguards highlighted throughout that give guidance to allow the court to intervene and set aside unfair agreements. That is everything I have to say. If anyone has any questions.